Hector Orozco Jr. was convicted of first and second-degree murder and various lesser charges. He appeals these convictions, arguing his constitutional rights were violated by a biased jury. Here's what happened. On the second day of testimony, Juror 13 informed the bailiff she received a call the evening before from a relative of the 82-year-old victim. The caller was a friend and said, "I hear you got on the jury with that guy that killed my nephew's wife's grandma." Juror 13 told her to stop talking. Before the call, Juror 13 was not aware of the connection to the case. Juror 13 was excused, and the defense noted this juror had been receptive to their case. They claimed the caller, Vicky, was attempting to influence the juror, and they moved for a mistrial. The mistrial was not granted. The defense requested the jurors be questioned individually to confirm they did not receive any information from Juror 13. The court declined and stated they would take her word for it. Mr. Orozco claims the court abused its discretion and violated his right to a fair trial and an unbiased jury. Let's get it started.
Okay, it looks like we are ready to go for the next case on this morning's calendar. It is State versus Orozco. Mr. Davis, if you could introduce yourself again and let us know how much time you would like for rebuttal. I know that you've been briefed on how our clock works. Just take note that once the clock starts ticking, it ticks from 15 to 0, regardless of whether or not you're in your rebuttal. The middle light will show you when you're in your rebuttal. So please proceed.
Thank you, Your Honor, and good morning to the court. My name is Oliver Davis. I'm with the Washington Appellate Project, and I represent Hector Orozco. This is his appeal from a murder trial in which he was accused of killing two individuals in Pasco. The issues we've raised are issues regarding the composition and the fairness of Mr. Orozco's jury. As the court knows, the first issue in the brief is the question of whether a particular juror should have been struck for cause based on something he said in his questionnaire about a connection to law enforcement. I'm very happy to answer questions about that issue, but I believe I would like to primarily focus on the second issue, which is the issue concerning Juror 13. Mid-trial, Juror 13 asked to speak with the court and the attorneys alone, and she indicated that she had received a telephone call from a close friend of hers, Vicky, and those were her words, a close friend. And Vicky had asked her, "Did you get on the jury?" And Juror 13 said, "Yes, but we can't discuss this." And apparently Vicky also said, "Did you get on the jury with a person who's accused of killing my relative's grandmother?" And again, Juror 13 told the court that that was the entirety of the discussion, that she hung up on Vicky, but before she did, she said, "I can't talk to you about this case now." She said, "I can talk to you about it later," but she said she couldn't talk about it now. There was the next day, it may have been later that day, it turned out based on some investigation conducted by the defense investigator, Mr. Porteous, that there were some things, according to Vicky and the investigator's discussion or questioning of Vicky, there were a couple of things that Juror 13 did not mention about the conversation that she had with her friend on the telephone. The most important of those is she did not reveal that her friend Vicky had used a derogatory term about Mr. Orozco and had again repeated, and this time by using that word and by mentioning it again, repeated even more strongly that this person was guilty of that crime. Once the facts of the entire conversation, based on what Juror 13 had said when she originally spoke to the court, and based upon what the defense investigator learned that she had said to her friend, or that her friend had said to her, but that Juror 13 had not revealed to the court, the parties...
The derogatory term, I believe, the friend Vicky referred to Mr. Orozco as a scumbag. Is that what we're talking about?
Yes, I apologize. That is
No, that's fine. That's fine. Now, Vicky didn't know Mr. Orozco, did she?
does not appear that she did
So
not.
the idea of him being a scumbag was the assumption that he actually committed the murder. And so whether he was a scumbag or not, people, the listener, the veneer juror would have known that it was implied that if Orozco killed the grandmother, he was a scumbag.
Well, Your Honor, I'm not sure that the caller, Vicky, who called Juror 13, said she did not know Mr. Orozco. She plainly knew about the case, and she knew roughly what had happened. There's no indication, however, that she personally knew the defendant. But the issue that arose that I think presents a significant constitutional question regarding the court's duty to fully inquire and investigate if it believes that the jury may have been tainted by prejudicial information is that the court, when Juror 13 was removed, the court said, "We've learned more about your conversation. We don't think that you should be on this jury," and she was excused. The defense counsel at that point wanted to know if the juror had told any of the other jurors anything about this conversation or anything about a phone call.
Didn't defense counsel only raise that concern the following day? It was my impression from the record that when Juror 13 was excused, he didn't ask then. It was the next day when he came back and he said, "I think maybe I'd like to have the other jurors questioned about this."
I believe that when she was being excused, she actually was asked if she told any of the other jurors about the call or the conversation, and she said no. And indeed, Your Honor, you're correct. It was the next day that defense counsel asked the court to inquire of the entire jury as to whether Juror 13 had said anything to them about the facts of the case or any discussion about talking with another individual about the facts of the case. The jurors aren't supposed to be talking about the case at all, but a very general and generic question could have been phrased by the court and asked of the remaining juror members to inquire if they'd heard anything from Juror 13.
Well, Judge Spanner expressed concern about, I think he said his term was opening that can of worms and the possibility of speculation. Do you not credit that at all? Do you see no danger to calling the jurors in and starting to ask them about, suggesting to them that this juror was excused for some reason that should be of interest to them?
I think that the court often does ask the jury relatively generic questions about issues that they might have experienced during the trial outside of the courtroom, such as, did you hear what the lawyers were talking about when they passed by you as they went to lunch? In this case, I don't think this would have opened a can of worms at all, because the court, in its wisdom, could have formulated a very generic question.
So what would the question have been?
I think the question would be, as I told you yesterday, sometimes jurors cannot continue in the case. Juror 13 is unable to continue, and that's why she's no longer here. May I ask any of you if Juror 13, during the time you've been in the deliberations room and during this trial, may I ask if Juror 13 has said anything to any of you about the facts of this case? I think that generic wording would in no way have suggested what Juror 13 might have said, might not have said, or implied to the court or to the jury that Jury 13 had engaged in some kind of wrongful conduct, nor would a generic question like that have revealed that Juror 13 was removed for a reason that had to do with her concerns, the court's concerns about her talking about the case. And the problem here is that the court has a duty to inquire, And when the court refused to ask the remainder of the jury whether the jurors had heard anything from juror 13 or whether juror 13 had discussed anything about the call
Mr.
with
Davis,
Yes.
Mr. Davis, you say that the court has a duty to inquire. The court did inquire the veneer juror if she talked to anybody, and she said no. Couldn't we give the court some discretion here to say, well, the court believed this person was forthright enough to bring it to the court's attention, the original telephone conversation, and perhaps she didn't attach any weight to the phrase scumbag for the reasons we talked about earlier, is because, you know, she thought that, well, the person's a scumbag only if he did it, and so I don't put much weight into what Vicky told me about him. Don't we have to give the trial court some discretion how to handle these things, because it did make some inquiry?
The court did make some inquiry. The problem about the refusal to make a simple further inquiry to the remainder of the jurors is that the trial court stated, I'm going to take her word for it that she didn't say anything about this to the other jurors. However, the defense investigators' testimony on the stand had revealed that there in fact was a certain tone and certain words used about the defendant and the case and what had happened that juror 13 had not revealed in her original discussion with the court. Now, whether this was because of lack of memory or a lack of truthfulness, because the court learned from the investigator.
Davis, I know that you're almost to your rebuttal, but I had a question for you. I'm just trying to distill what rule of law you're saying applies. So in the case of extraneous information coming to a jury, if there's credibility problems with the source of that information, it is an abuse of discretion for a court not to poll the jury as to the influence. Is that the rule of law?
Yes.
And if so, what authority says that it's an abuse of discretion not to poll a jury if there are credibility problems regarding the source of extraneous information going to a jury?
Your Honor, I believe Berhe and Cho are two cases that I cited on that point, and I will look more closely at my cases while the respondent's counsel
Yeah,
speak.
look at your cases, because it seems like a very specific action that it's not good enough to make a credibility determination. We will not defer to the court's credibility determination. When there are reasons to doubt credibility, you must conduct a jury poll. And if you don't, it's an abuse of discretion resulting in reversal. That seems like a very specific rule that I would want to know the authority for. But yes, have you reserve the rest of your time, if that's okay, and go to Mr. Jenny.
Thank you.
Good morning, Your Honors.
Good morning.
May it please the court, Frank Jenny in Pasco with the Franklin County Prosecutor's Office representing the state of Washington in this case. Before moving on to the second issue that was discussed by Mr. Davis, just wanted to briefly mention the first issue. Last week, we did submit a statement of additional authority on that issue, an unpublished opinion from December 3rd that we're citing as persuasive authority pursuant to General Rule 14.1. That's the case State versus Cantu, an opinion written by Judge Lawrence-Berrey, concurred in by Chief Judge Pennell and Judge Korsmo. And on page 14 of the slip opinion, the court states as follows quite clearly. We have previously determined there is nothing inherent in the status of being a police officer that would support a finding of implied bias in a criminal case. The court cites to the same published Division I opinion that we cite in our briefing. So there's certainly nothing to indicate that the juror in question was biased in any way. That juror was not a challenge for cause. And it's quite clear that the defense attorneys in their private conversations between themselves simply decided that they wanted that person on the jury. that wasn't the case, they would have brought that individual in for individual questioning and would have made a challenge for cause to that juror. Now, as far as the second issue is concerned, it's important to understand that this lady who was a juror number 13 was at all times very, very forthright with the court. Judge Spander was very impressed with this juror, and he made that clear from the record. The defense attorneys made clear that they saw that there was nothing improper done by this juror. They made that clear in their comments to the court. I'd refer specifically to page 669 of the report of proceedings, where the defense attorney said, Your Honor, I think it's clear no one's saying that juror number 13 did anything wrong. That's not what this is about. At another point, Judge Spander asked the defense attorneys, do you believe juror number 13 made any misrepresentations of fact during any point of the voir dire process? And defense counsel responded, no, and I want to make it clear that that's not the point. So everyone agreed that juror number 13 behaved quite properly throughout these proceedings. She was just a victim of unfortunate circumstances, and that she received this phone call from someone who was a relative of one of the victims in the case. It's important to understand also that there's no material difference in the recollection that juror number 13 had of the phone conversation and the recollection that the caller had of the phone conversation. Juror number 13, the way she recalled the phone call, and I'll just quote here what juror number 13 told the court. I hear you're on the jury of the guy that killed my great nephew's wife's grandma. That's the way she recalled it. The only thing that the caller added to that, beyond what juror number 13 says, that the caller recalled using this pejorative term. So by juror number 13's recollection, the caller said, I hear you're on the jury of the guy that killed my great nephew's wife's grandma. The way the caller recalled it, she said, I hear you're on the jury of the scumbag that killed my great nephew's wife's grandma. So both the juror number 13 and the caller remembered the caller having said that the defendant committed the crime. There was absolutely no difference in their recollections on that. The only difference in recollection that the two individuals had is that the caller remembered using this pejorative term, but since the juror number 13 remembered the caller saying that the defendant had killed an elderly woman, it's hard to imagine that the pejorative term made any difference. It didn't add anything to it. Whether you use a pejorative term or not, if you say that the person killed an elderly woman, there's just adding that pejorative term didn't add anything to it. So there's certainly nothing here to indicate that the juror was being untruthful in any way whatsoever about the phone call. On the contrary, she immediately cut off the phone call and indicated that she was not able to discuss the matter with this woman who called her. And immediately at the start of the proceedings, she called the matter to the court's attention and completely complied with everything that was expected of her. So it was just absolutely commendable the way she behaved, and Judge Spander indicated that as well.
Mr. Jenny, did
Yes,
juror 13 ultimately agree that the caller had used the term scumbag?
I don't think she recalled that. She didn't really recall that. I don't think the judge even asked her if she recalled that.
We're all operating under the assumption also that what the caller reported to the defense investigator and the defense investigator reported to the court was the true version of what happened. It could be that this caller often refers to Mr. Orozco as a scumbag, and she may have, misremembered whether or not she used the word scumbag. If she's calling a juror, I would venture to guess that she'd talk to others about this too. She probably had a lot of conversations concerned about this guy going to trial. So it's possible that the caller even didn't use that term when she actually talked to juror 13, isn't it?
Oh, that's certainly possible, Your Honor. The caller may have just remembered what she said when she made the phone call. Also, we didn't have any testimony from the caller. The defense investigator went out and talked to the caller, and the defense investigator briefly testified as to what the caller had told him.
He did say, though, that he had a recording of the conversation that he could play for the court if the court wanted, but nobody asked that it be played. Is that correct?
That is correct, Your Honor. And the state actually at that point decided out of an excess of caution to simply agree to have that juror excused. So that's why no one was belaboring the point, is that the parties at that point were in agreement that the juror could be excused.
Mr. Jenney, something that I think you brought to our attention in your briefing was that there was another juror on this panel who appeared to be hypervigilant and brought a number of things to the attention of the bailiff. The implication being that if juror 13 had recounted conversations with others about the case, that this hypervigilant juror would have reported that to the bailiff. Can you remind me of what that was?
And Your Honor, I have to apologize. I'm simply not recalling that in my briefing, but
Okay.
There were two jurors that were mentioned in the briefing. I don't recall another juror bringing anything to the bailiff's attention, but certainly juror number 13 was very vigilant in reporting the entire incident to the attention of the court.
I might be remembering something that came from our industrious law clerk.
I would attribute that to your industrious law clerk, Your Honor. Yes, I simply don't recall that from my own briefing. Your Honor, it's also important to understand, as we mentioned, that the defense did have an investigator working on this case. And so if there would have been the slightest indication that juror number 13 had in fact discussed this matter with her fellow jurors, the minute the verdict was returned, I think it's reasonable to expect that the investigator would have been speaking to the jurors and seeing if any of them recalled anything having been said by juror number 13. Also, the court is very accommodating in allowing counsel to talk to the jurors after the verdict is returned. So certainly if there was any reason to believe that juror number 13 had been untruthful about whether she had discussed this with her fellow jurors, there's every reason to think that the investigator and or the attorneys would have been talking to the jurors after the verdict had been returned. And if something had turned up, there would have been a motion for new trial made, and that would have been addressed. Counsel mentioned this State versus Berrey case, B-E-R-H-E. That's an entirely different situation. There actually was a declaration from one of the jurors that there had been discussions in the jury room suggesting racial bias and prejudice on the part of some of the jurors. That was included in a declaration from the juror supporting a motion for new trial. The trial court denied that motion for new trial without conducting an evidentiary hearing. The Supreme Court on appeal found that the trial court erred in not conducting an evidentiary hearing, that was something that required further investigation to make sure that there was nothing improper that occurred in the jury room. And so the court remanded that then for further proceedings, which presumably would have included an evidentiary hearing. Here, there's no substantive evidence whatsoever that juror number 13 ever discussed this with her fellow jurors. On the contrary, there's every reason to think that there was nothing whatsoever said to the fellow jurors. Juror number 13 testified to that. The trial court had the opportunity to listen to juror number 13, to weigh her testimony, and to consider it in the context of that she had been very forthright with the court and brought this to the court's attention. And trial court was certainly within its discretion in finding that there was no reason to doubt in any way juror number 13's testimony that she had not discussed this with her fellow jurors.
Well, she and her friend both agreed that when the friend called and started to talk to her about being on the jury, that juror 13 immediately said, "Stop, I can't talk to you about this now." And then I gather reported it the next morning to the bailiff. So it's kind of hard to believe that somebody who immediately stopped the conversation, immediately reported it to the bailiff, would then chat with her fellow jurors about the fact that the conversation took place. It seems incongruous that behavior would be incongruous with what she'd done up to that point.
And that would certainly be the state's position, Your Honor. And Judge Spanner, even while excusing juror number 13, told her that he was just absolutely thrilled with the way she behaved in immediately ending that conversation and immediately reporting that to the court the next morning.
There's an implication in your opposing counsel's argument in his briefing that there was something improper about juror 13 telling her friend that when the trial was over, she could talk. Do you have a response to that?
Well, my response is that that's not improper. Once the trial is over, that they could talk, but juror number 13 immediately realized that that's something that could not be occurring at that time. And juror number 13 certainly realized it would be improper to be having any conversations while the matter was in progress. And really, juror number 13 was on top of everything and saw that there was a need to immediately bring that to the court's attention. And as far as asking the other jurors, I think Judge Spanner, in the exercise of his discretion, realized that would have opened up speculation to just saying, did she tell you about the phone call? Did juror number 13 discuss something that occurred outside the courtroom? That would alert the jurors to the fact that something had occurred outside the courtroom. Did she discuss the facts of the case? That would alert them and result in speculation. So the trial court acted entirely within its discretion. And so we would ask the court to affirm the conviction for the reasons we stated in our briefing.
Thank you, Mr. Jennings. Mr. Davis, your rebuttal. You'll need to unmute yourself. Thank you.
Can the court hear me?
Yes.
Thank you, Your Honors. I do want to make sure that I address Your Honors, Judge Pennell's question about case authority. I'm looking most primarily at State v. Winmore, and that case argued that, or stated that due process required the trial judge, once aware of a possible injection of bias, to determine the whole circumstances and the impact on the jury. Berrey is also, of course, a case that is factually somewhat different, but thematically very much the same as this case. That was one where a post-trial at the motion for new trial stage, the court learned that a juror believed she had been pressured to issue a verdict or vote in a certain way because of her race. 5 other jurors sent in affidavits saying no such thing happened. A 6th juror sent in an affidavit saying, I think something like that was happening. And the Berrey court said that for the court to refuse to go further into a further investigation of the entire jury to try to determine what exactly happened was an abuse of discretion and a violation of the defendant's constitutional rights. So,
Mr. Davis, how do you respond to Mr. Ginny's statement that once the trial was over, that the jurors could have been questioned on this topic by the investigator or by defense counsel? How do you respond to that?
well, I respond to that by saying once the egg is cooked, it's hard boiled. I mean, once the verdict comes in, there's a presumption of finality and a presumption that it's going to stand. And attempting to overturn a verdict that has already been issued is a much different effort than trying to, mid-trial, when one can do something to make sure the process is fair, asking the court to do what it needs to do to conduct an additional inquiry. Now,
But isn't that the distinction between this case and Bear? And Bear, people did talk to the jurors, and no one's saying that if you came back with information from jurors that juror 13 was lying, it seems like that would be a very strong petition for post-conviction relief under our case law.
well, that might well be, but in this case, there was reason to doubt juror number 13's accuracy. And I think it's important to note that this is not an allegation necessarily of dishonesty. It doesn't matter whether she was honest or dishonest in what she said she did or not say to the other jury, or whether her memory was simply inadequate. When she first spoke to the court, she gradually remembered more things. So this is not an attack on this juror for being dishonest, but she was not completely accurate. And given the court's duty to make every reasonable inquiry to whether bias infected the entire jury, it would have been so easy, contrary to the examples of questions that respondent has phrased. It would have been so easy to ask a very generic question of the remainder of the jury.
Now, Judge Spanner is a veteran trial judge, an excellent trial judge. So do you really think it would have been so easy for him to ask a question without having some legitimate concern about causing speculation among the jurors?
I think it would have been. I think the question simply could be phrased. Juror 13 is departed. As I told you yesterday, people sometimes can't continue. May I ask, did Juror 13 discuss with any of you anything about the facts of this case? And if the answer was no, the answer would be no. But if the answer was somebody raises their hand and says, well, yes, she did mention a phone call. But the question that the court could ask to root out that possibility of an injection of bias could have been so generically phrased, it could have been so easily posed to the entire jury. And the harm that would have been avoided if the juror had injected bias into the process, the harm that could have been avoided by that very easy question was a terrible, horrific harm, which is a defendant convicted of these extraordinarily serious crimes by a jury who may have learned something about the facts of the case from another juror. Again,
And Mr. Davis, we have let you go a couple of minutes over. I wanted to make sure that you answered Judge Siddoway's questions. Unless there's any questions from the rest of are there questions from the judges? Okay, thank you very much for your submission. I think we understand your position. Your briefing and your argument today has been very helpful. Thank you. We do have 3 more cases on the calendar. I want to make sure we get to those.
Thank you, Your Honors.
Thank you. This case is under submission.
The court found the defense did not attempt to dismiss Juror 32 for cause, and he did not demonstrate that extraneous information had been provided to Juror 13, who was excused prior to jury deliberations. No abuse of discretion was found, and the court affirmed his conviction. There you have it, folks. Should he have instead argued inadequate counsel regarding the review of Juror 32? Share your thoughts in the comments below.